In this installment of Washington Legal Foundation's LegallyBrief.com, Joe Warin of the law firm Gibson, Dunn Crutcher will discuss non-prosecution and deferred prosecution agreements and how they fit into the scheme of enforcement of white-collar criminal laws.
Deferred prosecution agreements and non-prosecution agreements are Department of Justice's newest weapons of choice against companies. DPAs and MPAs are pretrial diversion agreements to cooperate, pay fines, perform remedial actions, and commit to federal monitoring in return for the ultimate dismissal of the charges. Rather than risk the collateral consequences of an indictment and potential conviction, companies enter into these agreements to avoid those sanctions. Prosecutors are increasingly using DPAs and MPAs. Between 2002 and 2005, there was twice as many of these agreements as in the previous 10 years combined. In 2007 alone, there were 35 DPAs and MPA agreements. This is a 75% increase from 2006. Prosecutors are using these agreements inconsistently. A corporation in New York may be granted an MPA, while a corporation in Texas might be indicted for essentially the same alleged crime. This disparate treatment also extends to the terms of the agreements themselves. These inconsistencies lead to an unhealthy environment, particularly for mergers and acquisition activities. They create needless uncertainty and confusion for companies and their shareholders. Consistency and predictability are hallmarks of the Department of Justice policies, but are missing for corporate prosecution guidelines. More troubling, however, is that there are inconsistencies mean and similarly situated companies are treated vastly different at the whim of a prosecutor. This basic unfairness should not be perpetuated by the Department of Justice. To remedy the problems resulting from the current practices, DOJ should enact two reforms. First, DOJ should provide guidelines to prosecutors for MPAs and DPAs. Prosecutors should charge criminal charges if a company is dominated by a culture of corruption. However, a company should be offered a DPA if the wrongdoing was not rampant, but DOJ had reason to believe that significant remedial measures are necessary to rehabilitate a company. A company should be offered a NPA where the wrongdoing was isolated and where the company both complies with the Thompson-McNulty memo and cooperates with the prosecutors. The second reform that should be enacted is instituting guidelines for the terms of DPAs and MPAs, such as fine amounts, duration, and the need for an independent monitor. Should DOJ use the Sentencing Commission as a model to form a task force creating with standards to avoid the inconsistencies in the issuing of the terms of DPAs and MPAs. MPAs and DPAs have the potential to punish and deter companies without destroying them. They are important and useful tools for prosecutors. However, without providing clear guidelines delineating their use, DOJ allows for troubling inconsistencies that harm companies, their shareholders, and the public.
The subject of this LegallyBrief.com is discussed further in Washington Legal Foundation's special report, Federal Erosion of Business Civil Liberties publication, which is available on Washington Legal Foundation's homepage. The chapter on deferred prosecution is Chapter 6.